Let's do it.
Welcome to this Battle of Ideas session, Rape and the Law. He said, she said. My name is Luke Gittos. I'm going to be your chair for this discussion, and I'm a paralegal at Human Solicitors working in criminal law. Just to introduce our speakers, first to speak will be Helen Reece, who sat just to my left. Helen is a reader in law at the LSE, focusing specifically on family law, but she's involved in researching the regulation of human intimacy in the family law context, which makes her contribution obviously very relevant to the discussion today. Second to speak will be Marguerite Russell, who is a leading criminal barrister working in criminal law and human rights. She works for Garden Court Chambers, which, if I'm correct, I think Marcel Berlin once described Garden Court as the last Marxist chambers in London. And I'm not so sure how she will take that, or whether it's true, but at least we know what Marcel thinks. Sat to my right is Professor Dan Subotnik. Dan is a professor of law at Touro Law School in New York. He's written on the issue of rape and the issue of rape in relation to the feminist discourse for a very, very long time. He's written numerous articles on the topic. Just one which I found particularly interesting was Copulemus in Pace, a meditation on rape, affirmative consent to sex, and sexual autonomy. So Dan we're particularly excited to have Dan here, and I think it bears special mention that when we were having the discussions for this session and deciding which speakers we should get, it was suggested that we would throw a speculative arm across the pond to New York to see if Dan would be able to attend, despite us not being able to pay any airfare, and despite us basically being able to provide the very, very basics of accommodation here in London. Suffice to say that Dan has brought himself here off his own back to contribute to the discussion here. It's clearly evidence that he thinks this is an extremely important debate to be having out here. It goes without saying that this is perhaps an extremely difficult discussion to be having. It came about as a result of statistics and research that came out earlier this year, indicating that the majority of women thought that some rape victims should take responsibility for being raped. Three-quarters of them thinking that if a woman got into bed with a man, having been out on a night out, etc., then that should give some indication that they were in some way responsible for being raped. Now, the reaction to this in the media was a kind of hysterical furore, suggesting that women were adopting the same kind of chauvinist attitudes that emerged around rape discussions in the 60s. But at the Institute of Ideas, we thought that these were worth perhaps interrogating a bit harder and seeing whether or not there was something else going on here. So that's what really led us to this discussion here today. And it's also worth thinking about the fact that the definition of what rape is has expanded since the 1960s, not simply in a legal context, but I think also in an important way our cultural understanding of what rape is has changed and has expanded. And whilst that has obviously had an extremely positive tenet in one sense, in that it has brought to light numerous offences which may have previously gone undiscussed or uncharged, there perhaps is also some problematic aspects to having a broader definition of rape. We seem more willing now to delegate our responsibility for negotiating our sexual encounters to the state. And whilst that's obviously in some contexts a positive thing, there is some serious issues to be had out. So I'm not going to say anything more. I'm going to pass over to my panel. I'm going to start off with Helen.
So in the next few minutes, what I do want to talk about is attitudes. And I want to talk about, more specifically, I want to talk about our attitudes to rape, rape victims, rape trials. And I want to talk about what rape reformers and rape campaigners, and indeed, to a large extent, the government, think about our attitudes to those questions. And the reason I am going to focus on attitudes in what I say is that, as Luke outlined in his introduction, over the last 20 years or so, there's been a huge amount of reform to the law of rape. Those reforms have led to a situation where the definition of rape has expanded. And there's been really so much reform in this area that for a lot of rape reformers and rape campaigners, there's an acceptance that really the end of that road has been reached in terms of reforming the law of rape, if we are going to have anything that approximates to a presumption of innocence in rape trials, if we are going to have anything that looks something like a fair trial, then a wide number of rape reformers and rape campaigners accept that the end of that process has come. And I think the Stern report is interesting in its acceptance of that. So that has led then to a turn to interest in the public's attitudes to rape victims and rape trials. So the argument that's put forward is that where rape victims are still getting a raw deal, that's because we, the public, basically have a bad attitude to rape and to rape victims. Essentially, what rape reformers and to a large extent the government is saying is that we, the public, are in thrall of what they describe as rape myths, or to put it perhaps even more unpleasantly in my view, that we, the public, have what is described in the literature as rape-supportive attitudes, which is obviously a really horrible thing to be said and to think about yourself, that you might have an attitude that in any way supports rape. And this really matters, this focus on our attitudes, because it's given rise to a huge range of new proposals for reform, really ranging from, in my view, the sublime to the ridiculous, although I'll let you decide which you think are which. At one end of the scale, we have public information campaigns, like the one that you may have looked at on the website advertising this session, really to educate us out of our bad attitudes on rape. At the other end of the scale, we have proposals to get rid of the jury in rape trials because the jury can't be trusted because they have a bad attitude on this question. Of course, that does rather beg the question of who can be trusted to decide rape trials because, for example, Jennifer Temkin, in her book on attitudes published a couple of years ago, runs through the whole gamut of different players in the criminal justice system, from judges to police to the CPS to the juries. And she finds that sections of all of those groups have a bad attitude to rape victims. So it does raise the question of who on earth can be trusted to hear these cases. But actually, what I think about our attitudes, public attitudes to rape, is that they're broadly speaking okay, that people do generally have quite reasonable, quite sensible attitudes to the question of rape. Of course, I recognise that some people do have misogynistic and sexist attitudes. It would be absurd to suggest that everybody has a progressive attitude on this question. But I do think that those regressive attitudes are in the minority, they are on the way out, and that most people have a decent attitude on this question. And I think what's really happening here is that rape reformers and rape campaigners are describing as rape myths those views that they don't agree with. And they're describing as rape-supportive attitudes those attitudes that they don't share. And I think this is a very dangerous thing to do when you're talking about an issue which is, as Luke said in his introduction, on the one hand, highly contentious, politically charged, and on the other hand, at the same time, deeply personal, deeply intimate. We're talking about those attitudes which we hold very dear and are very, very personal to ourselves. And if the chair will let me, I'd like to illustrate this point really with the example that he started off his introduction with. These headlines earlier this year, and we've seen them repeated, that 1 in 3 people blames women for being raped. That was the headline in The Guardian, and as Luke suggested, that was repeated really throughout the media. And where this comes from is that a number of surveys have been carried out where members of the public are asked, they're given a range of situations, a woman flirting, a woman going back to a man's house for a drink, a woman wearing a short skirt, a woman being drunk, etc. And they're asked questions about those different scenarios. And then those results are aggregated and we get the headline 1 in 3 people blame women for being raped. But actually, when you look at those surveys, they don't suggest anything of the kind. All the surveys that I've looked at on this question never mention the word blame. They all ask people, do you think a woman bears some responsibility? And responsibility is an interesting word to use because it faces very much two ways. On the one hand, it does face towards blame, but on the other hand, it faces towards causal attribution. And it's really impossible from those survey results to know how much people are saying that women are to blame and how much they are saying, well, if she had behaved differently, maybe this would not have happened. And that gets lost in the media reporting. And I have to say, in the reports by the people who carried out the surveys themselves, they lose that focus on responsibility as opposed to blame. And I think what's happening with these survey results is that we are getting what I would describe as a feedback loop. Because what's happening, I suspect, is that the public, in answering these questions, know that the definition of rape has been widened, and when they're answering these questions, they're grappling with how to answer them, knowing that situation that we have a broader understanding of rape. And the example that I was going to use is the one that Luke mentioned in the introduction, which is the 2/3 of people who think that somebody bears some responsibility for being raped if they get into bed with the person. And as Luke said, in fact, it's more women than men who think that there is some responsibility in that situation. Now, if 2/3 of people think that when you get into bed with somebody, that then entitles them to pin you down, put their hand over your mouth to stop you screaming and force themselves on you, then I would agree that that is a problem. That is not a good attitude to have. But if 2/3 of people are grappling with a wider definition of rape, and what they're saying is that when a woman gets into bed with a man, she is sending a message that she is open to have sex, and that man is entitled to take that climbing into bed as a green light. And then, in the absence of any clear message the other way, in the absence of her then making a very clear signal the other way, whether it's saying no or whether it's pushing him off or whatever, then they are uncomfortable with the fact that that is described as rape, and they are uncomfortable with the man being found to be guilty of rape, then I think that is a very sensible attitude and indeed a very reasonable attitude. So to finish off, I don't want to be educated out of my attitudes on rape by rape reformers or by the government. I don't want to be shown a public information broadcast. I don't want to be handed a leaflet, and I definitely don't want to be stopped from sitting on a jury. But of course I do welcome a genuine debate about those attitudes.
Great, thank you, Helen, that's very useful. Marguerite?
Up until 1976, rape was a common law offence. It meant there was no statute. And there were 3 basic rules so far as rape were concerned. One, it was an offence that needed corroboration. You couldn't just be convicted of rape if it was a woman saying that she'd been raped. Why was that? Well, we all know that women and children are complete liars, and therefore they have to be corroborated. That was a myth that continued and does continue. Secondly, you have to report it to the police almost immediately, because if you don't, then you won't be convicted. We can see how successful that was in the recent London taxi driver case. So I actually called my talk a question of attitudes, but I'm concerned much more about the attitudes in a society which still basically does not give or treat women as equal citizens. And the third thing was that a woman couldn't be raped by her husband. And while we get really smug about how advanced attitudes are in the West, and no doubt we all read, and I'm going to jump ahead, about the young Afghan women who were stoned by men when they complained about the Afghan government allowing a law that allowed basically women could not withhold with consent in marriage. We should remember that it wasn't until 1991 in this country that a woman had a right to withhold her consent in marriage. So let's just, as it were, take this supremely. Gosh, aren't we in the West so advanced in our attitudes? Because we're not. The other thing you should know about rape law is up until quite recently, it was treason to rape the daughter of the monarch, in this case it would have been Princess Anne, unmarried. The minute she married, it was no longer treason. It might be a very serious offence, but it wasn't treason because she had passed into the property rights of her husband then and wasn't of great value to the crown. So when I talk about attitudes in relation to rape, I want to make it absolutely clear that I come from a perspective that says to me, attitudes in rape come from the same place as attitudes towards women. They come from the same place as attitudes, for example, towards women's economic disadvantage, towards pornography, and so on. And if we are going to change attitudes towards women, rape is one of the areas where it still needs to be changed. Why do I say that? And it's all, I hate playing with statistics, but if you do look at the Stern report, when it's rape of a female, there's a 47% conviction rate by the jury for those trial. When it's rape of a male, it's a 77% conviction rate. There are fewer cases for rape of males, but that is indicative that as witnesses, men still have a higher value than women. I want to give an example. When I first started, I helped set up the first rape crisis centre in this country way back. And in 1977, I spoke to a woman who was an executive who'd just faced a rape trial at the Old Bailey. And she was an executive with Shell. She was from the US. She was very high-powered. This guy had broken into her flat, had raped her repeatedly, and then he'd left and taken property. The jury acquitted on the basis of the rape, on the basis that he might have reasonably believed that because she talked to him throughout and was pleasant, that she had consented to that. But they convicted on the burglary because they knew damn well that she wasn't really giving her property away. Now, it is that mindset that kind of distinguishes the sort of attitudes to what consent is about that really is the troubling thing with rape. The other thing I want to say is, I don't know how many of you read in The Guardian last week. There was a very good article by a young man on pornography, an anti-pornography article. But one of the things he was talking about was one particular piece of pornography, which basically was a group of young men driving around in a bus. They pick up a woman. She immediately agrees for money to have sex with them, and then they throw her out. And it's called slut bus or something. I know it's completely hideous. But it's those kind of attitudes which the idea that anyone could create that as any kind of reality, or even that the fantasy could blur into reality. The huge growth in pornography that's occurred, I think, and that certainly when it started was the idea that, oh, gosh, if we have pornography, there won't be so many rapes. If there's pornography, rape and sexual assault will diminish. It hasn't. Attitudes towards women, there's a link with domestic violence. I'm just going to throw that in. But when we think about rape, just remember how recently and in recent times, as there has been, as it were, a global movement for women to try and reach equality of a kind. I want to mention Kosovo. I want to mention the Congo. There have been mass rapes of women as weapons of war. And what is that about? If it's not about how serious this is within the attitude of relationships between men and women. And one final point on attitudes. very recently there was a debate when this new government came in. Their first one of their first things was that they were going to make men who were accused of rape anonymous in the way that the victims were. Firstly, there's a huge mythology about that. There is anonymity granted to witnesses, not just in rape case, but in a number of cases these days. For good or ill, it is something that has come into the criminal process. All victims of crime can give evidence behind screens or from different locations if they are nervous, not just rape victims. But why were the government in this country so eager to come up with anonymity for people accused of rape, not for paedophiles? Because let's face it, if you're wrongly accused as a paedophile, just as damaging to your reputation. And this was their comment. Crispin Blunt, sex crimes are of an entirely different order. Ken Clarke, tit for tat because the complainants are anonymous. And the Prime Minister was quoted as saying, and it's back to the myth, we know that a lot of people are falsely accused. So I think that sort of women have achieved some good results in this area, but we have a long, long way to go before we change society's attitude to both women and rape. Thank you.
Dan.
Thanks, Luke, Helen, and Marguerite. Perhaps unlike them, I take no responsibility for your reactions today, and that's because Luke has told me that my job is to rile you up. Several years ago, I was mugged, you might be interested to know, and I had nightmares for years about that. And so I want to raise the question, how bad is rape? Here's the answer provided by Michel Foucault, French culture theorist. There is no difference in principle between striking one's fist into someone's face or one's penis into one's sex. That is the response, perhaps, or the ideology of a bully. I reject it, and undoubtedly everybody else in this room rejects it. But it gives us a sense of at least some elements of the population and their response to rape. You have to have some sense of how serious rape is if you're going to deal with the problem. Now, we've come a long way, as Marguerite suggested, in recent years. Number one is in most Anglo-American jurisdictions, we've abolished the corroboration requirement. We have lengthened the statute of limitations for reporting rape. We have enacted rape shield statutes, which preclude discussions about the complainant's sexual history. We have stopped giving jurors warnings about how unreliable women are because of feelings of guilt with respect to sexual activities, which leads them to become delusional. And finally, we have eliminated the requirement that women resist to the utmost. That was the common law rule, at least in the United States. All of these changes have helped in the prosecution of rapists, and they are to be commended. We still have too much rape, and the question is, where do we go from here? Now, the latest incarnation of efforts is in something called affirmative consent. Affirmative consent is the idea that the consent of the female has to be clear and unequivocal, and that furthermore, no should mean no. Now, let's put this a little bit into context. The historical rule was that, as suggested a moment ago, rape required force. That was an element in rape, and that the woman had to resist to the utmost, and surely we've come a long way, and no means no is part of the law in many jurisdictions. Scotland requires consent. Canada probably has the clearest requirement of consent in a declaration by the Supreme Court of Canada, which says that consent cannot be implied. Even that has been problematical for rape theorists, because the problem is a lot of sexual activity and charges of rape take place in the context where alcohol has been consumed, and it's very hard to make a decision about how much alcohol precludes real consent on the part of the woman. To respond to this problem, there's a new movement afoot called Consent Plus that I want to talk about for a moment, and to help capture the ideological underpinnings of this, you might consider this phrase: the question by a critic, the question the law asks is not whether the woman intended, wanted, or desired the sexual activity, but whether she allowed it to take place. So the distinction that this critic wanted was between allowing it to take place and wanting it to take place. And the question is, how do you make that decision? You can't psychoanalyze every complainant, and even if you could, you'd probably not come out with a good answer of what the motivation for the sex was. And this has led the proponents of the Consent Plus movement to introduce a romantic idea of sexual activity, that the partners should talk in advance, declare themselves one way or another, either declare kind of permanent connection or to declare immediate attraction or something, so that there is at least a statement of mutual desire, mutual readiness to engage in sexual activity. Sounds good, but does it make sense? I want to suggest, and I think nobody's going to disagree with me, that sex is not only a human activity, it's an activity that human beings share with horses and rats. And as a result, there are certain things about sex which do not lend themselves to the kinds of conversations that the sex plus advocates or the consent plus advocates are calling for. And that's the problem. Sex is an animal act, and to the extent that we don't recognize that it is an animal act, at least in part, we are precluding full enjoyment of our sexuality. A consent plus standard, in short, gets in the way of our enjoying sex as, at least in part, an animal act. Now, there are also psychological studies that I think militate against a consent plus standard. Some years ago, a number of women academics in the United States questioned students and others about how they manifested consent. And the choices were direct verbal, direct nonverbal, indirect verbal, indirect nonverbal, and no response. Now, you might want to think for a second about how you might manifest consent in this room. And my guess is you'll be surprised to know that the plurality answer, I think it was 39% of the women in this study indicated that they manifested consent with no response. No response. Now, what does that mean? It means, I suppose, that at the very least, if a woman is on a couch with a man and the man starts undressing her and she says nothing, that she is manifesting consent, right? No words have to be offered in one direction or another. That is the least that we can infer from this study. That is, in fact, how Lady Chatterley herself manifested consent 100 years ago. Now, there's another study that kind of highlights the underpinnings of this first study, also conducted by a number of women. And the question that was posed to these women was, why didn't women respond with more gusto in so many cases to overtures by the men in their lives? Why were they, in effect, simply letting themselves be undressed as a manifestation of their assent? And the women responded by saying they were concerned about appearing promiscuous, uncertainty of their partner's feelings, moral or religious reasons prevented them from actively engaging in the sex in question, self-consciousness about their own bodies, and finally, wanting men to beg. Now, if women say no when they mean yes, at least in some circumstances, does it not follow that silence is more likely to mean yes? The silence, as indicated, of simply letting yourself be undressed. I've gone even further than this, and I decided that all these theoretical arguments and discussions really needed some more empirical backdrop, and so I did a study of students in my own school. 300 students responded, and I asked a number of questions, and I think you'd be interested in the answers. Sam and Vivian, age 25, had gone out on several occasions. After dinner and drinks again, Vivian invites Sam up for a nightcap. He kisses her, she kisses back. He puts her hand on her genital area. No response forthcoming from Vivian. Sam places his finger inside Vivian. And the question was, has Sam committed a felonious act? And the answer is no. Men and women said no. This was not a felonious act. This is not rape. 22% of the women said it was a felonious act, and 14% of the men said it was a felonious act. Obviously, there is the conclusion of the respondents to this survey was that there's some kind of assent that was manifested by Vivian, and that Vivian had an obligation to stop proceedings when things got kind of beyond her ken of desire. And then I upped the ante with the students, and I said, okay, Vivian does not resist, but does not express consent actively, and Sam now proceeds to have intercourse with her. Is that rape? And the answer here again was no, by a large majority of women and a larger majority of men. Again, I guess the idea is that Vivian has an obligation when she puts herself in that position, that women have to be presumed to know what they're doing, particularly in this day and age, and that there is no way of knowing what women want without asking them. Should we rely on race or rape theorists to tell us what women want? We don't have any basis for changing the law in the absence of studies of this nature. That's not to say this is, that this is not to say that this is the last study that can be done, but studies like this would seem to be central to the reform project.
Dan, and to some extent also Helen, has thrown up a challenge to effectively say, look, Does rape law take women's autonomy seriously today? Does it effectively say, look, consent is something which women can only do if they say yes, and there's no other means by which a woman can indicate that she might want to have sex with someone? That seems to me to be a bit problematic. How would you respond, Marguerite?
Okay, can I just comment on the Foucault thing? What is the difference between having a punch in the face and being raped? I'll tell you. If you're raped as a woman, and this may not hit male consciousness, you are going to worry about being pregnant, you are going to worry about STDs, and in this day and age, you're going to worry about AIDS. And given the choice between being punched in the face and being raped, guess which most women would take? Foucault may not have understood that, but I think most women do. The question right at the end of Dan's speech, which I really couldn't resist, we don't know what women ask. Well, fucking well ask them.
Well, on this point about whether Foucault was wrong or right and what's worse, being punched in the face or being raped, I'm afraid that my answer is that it does all depend. As we're seeing the expansion of our understanding of rape, both in the law and in public understandings, the only answer that you can really give to that is it all does depend on the circumstances. Of course, Marguerite's right to talk about all the consequences that can follow from being raped. But I'm not going to say that necessarily if a husband puts his penis into his wife's vagina when she is asleep, that is necessarily the most serious thing that can ever happen. It is rape. It's quite unproblematically rape in the eyes of the law. But I'm not going to say that it's necessarily the most serious thing that can happen. Consent is a very complicated concept, and there will be a line where a woman is unsure about what has happened. I'm not going to say that necessarily every time that somebody has an experience that they're unsure about, that they're unhappy with, that is necessarily the most serious thing that can ever happen. I think it all depends on the circumstances. Similarly, if a woman is very drunk and, in the words that we used to use 20 years ago, but we don't use anymore, that she is taken advantage of, I agree that will be rape if she's gone past the point where she's capable of consenting. I think that there is the point where somebody is too drunk to consent. Definitely if she's passed out, there's no question about that. And I think that the law is right to say that there is a line where somebody is conscious, but they are not capable of exercising any kind of meaningful consent. Is that the most serious thing that can ever happen to her? It all depends. It depends on her reaction and how she feels about it. If a woman does not have the capacity to consent because she has learning difficulties, again, I think the law is right to recognise that there are circumstances when people are not capable of exercising consent. If she has sex without her consent, is that the most serious thing that can ever happen to her? It depends. It depends on her reaction.
As Helen and to some extent Dan as well have suggested, that consent is a complicated process and one which can take place throughout an encounter. And if you looked at a lot of the rape campaigns that are around today, that seems to be bypassed in favour of a kind of yes and no approach. I'm just interested, Marguerite, whether or not you think that is a positive development. Because it seems to me that also that the change in rape law that's taken over from the past 30 years does also have a positive dynamic in that it's allowed things like date rape to be recognised, and the fact that husbands can no longer rape their wives. That's undoubtedly a positive development. But there's another tenet to that expansion of the definition of rape, which is a kind of relegation of female autonomy to say that they can't give their consent without saying yes. Now, do you think that's a positive development?
The problem is, if you look at the definition of rape, a lot of this discussion is not making sense, because the definition of rape in this country is: rape occurs when somebody intentionally penetrates the vagina, anus, or mouth of another person with his penis. That other person does not consent to the penetration, and the perpetrator does not reasonably believe that the other person consents. That's the definition, right? So in all these sort of little examples given, it's obviously a reasonable thing. She's responding in some way, she may not be verbally responding, etc., etc. But the fact of the matter is that this debate, what I'm suggesting, is concentrating on the woman's attitude rather than on the man's attitude. I spend part of my life in Canada, and the Canadians have just dealt with this very simply. if you're a guy who's going to have a sex, then you take responsibility. You don't lay it all on the woman. And that's as simple as it comes. And I like the thing about rats, and we're rats. Well, we're also animals when it comes to food, but on the whole, we don't think that we have to have it raw just because we are animals.
I'm actually really glad Marguerite mentioned that. I'm going to come out to the audience after I've just asked Dan a question, because I actually don't agree that sex is an animal act. I actually think that human beings are more rational than rats. And I think that maybe we can actually, why not put in a little bit of effort before we take that important step of engaging in a sexual encounter to actually make sure that the other person is consenting. It doesn't seem to me to be a huge job. And also, I mean, I think the idea that you are in effect also relegating both the man and the male and the female's autonomy in that sense. If you're saying that, look, animal instincts take over when people enter into a sexual encounter, and this completely bypasses any responsibility we have to ascertain whether the situation that we're entering into is wanted by both sides, I think you're actually having a negative impact on the autonomy of human beings, Dan.
I did not say that we should give in to our animality entirely. What I was saying was, in part, that explains part of human sexuality, and that makes a difference. Sex is not contract. And it can't be contract because of the animality. Thirdly, let me respond to Marguerite's analogy about the open door. I think that's a false analogy. There is sex is entered into willingly in many cases. An open door, an open home door, is not an invitation for people to come in. It is probably the result of someone who forgot to close the door. But nobody gets any pleasure, or few people get any pleasure, in having their home and their persons violated when they leave the door open. But if they do get pleasure from sexuality, then we can interpret an open door, or its analog in the conversation that we are having, slightly differently. And that's why I reject the analogy.
I agree with the idea of attitude, and I just want to point out that we're talking about attitude of women, but we're not talking about attitudes of men. So, for example, if a woman lies on a beach naked and she's sunbathing, some men may think that she's actually inviting them for a certain act, right? So, in rape question, we're dealing with attitudes of certain males who think that a certain behavior means or implies certain desires. And the difference in male attitudes to these behaviors on the part of the women are actually key in deciding who is to blame.
Coming back to your example that you just took issue with, I have an issue with your example too, in that your thing about the open door in the house, there is a legitimate excuse here in law. It's a lawful excuse. If you legitimately believe that somebody doesn't mind you going and taking their goods, or you have reasonable belief that's the case, you have a lawful excuse against theft, and that seems to be there already in law, so it is actually something that is nuanced and is discussed in court if these things do come up. I also think your example of why that's wrong is probably a stronger response. The other issue was the sort of nuancing and laying on the beach thing, and the issue with attitudes. That is the crux of what was changed in British law relatively recently, is that rather than it being just the attitude of the accused rapist, or person accused of rape, it's now whether or not their attitude was, whether or not a reasonable person in their situation would have that attitude. And that was, I think, the crux of what was right about the law. And that is why where it stands now is right. And I was a bit confused by your argument, because I thought, on one hand, I thought you were sort of here to argue for an extension of the law. But then you did come back to sort of defending where it is now. And if it is where it is now in writing, that seems to me to be fairly right. But where people argue it should go is when I get concerned.
For me, it's quite simple. Consent, to me, is active. You ask and you stop if you get any signs that that person is not engaging or has changed their mind. If a guy I'm with doesn't have an erection, doesn't look like he's enjoying it, isn't engaging with me sexually, I stop, I ask, and I continue to do so during the sexual act. I was raped at 14 and 15, and everything you're saying is highly relevant to the situation I was in, and I'd like to share something with you if that's okay. I blame myself for a very long time for not saying no to this person verbally, but I think the word no is a legal construct. It is very complex and confusing in these situations, but it would be very nice if in every confusing situation a man actually stopped to ask you, and I'm writing a book on this, I just want to read something to you. It would be very nice if in every confusing sexual interaction a young girl could actually look into a man's eyes and say no, but mightn't it be even more helpful if they actually bothered to ask? Because one thing for sure, I can't recall in any of my potential or actual situations of sexual assault was a perpetrator stopping to ask me if I wanted it. There was always some kind of an assumption of entitlement that just by being female, at being with them at that time, I wanted whatever they wanted to take from me. And there's a reason why perpetrators don't ask, because they don't care what you want. It certainly makes it easier if you appear to want it, but it usually doesn't matter to them either way. And this is the fallacy of any rape law that puts the onus on a survivor to prove that they didn't want it. I would like my perpetrators to prove that they did. And by the way, I spoke to my rapist last year. He had absolutely nothing to say about what he did. He had no understanding of what he did. Any law that places the onus on victims to prove non-consent treats men as dumb and sexually ignorant. It assumes men know nothing about female arousal, that they couldn't tell an unaroused vagina from an aroused one. They can't tell if there's lubrication or not, whether the vagina feels too tight, whether the girl or woman is in pain. That when they're in the most intimate, vulnerable, sensitive area of a girl or woman's body, literally thrusting repeatedly up inside the middle of her body, they can't tell the difference between pleasure or pain on her face. This is total, unmitigated bullshit. Men who abuse or have abused, crossed a line, pushed a bit too hard, talked her into it, maybe went a bit too far, choose not to concern themselves with consent. Female bodies give many, many signs of willingness or non-willingness. If a man was with a deaf or mute woman, how would he know that she consented? He would have to read her body. He would minimally have to look into her eyes. In my experience, men do not look into your eyes when they sexually assault. They focus on your bits, your body parts, and what they're doing to them. They don't see you as a whole, and taking notice of your eyes and your body's signs might remind them of your humanity. Thank you.
You sound to me like an anti-feminist. I like to think of women as resilient, powerful, able to say no, and having the ability to, unless they're in some sort of difficult
the Congo or Kosovo or somewhere like that.
Right.
Yeah.
So let's stay Western for this conversation.
Yeah, because it doesn't happen here.
Okay, so I would like to think of Western women as having resilience. I'd like to think of all women as having resilience, but particularly when you're talking about husband and wife rape, and you're talking about Western countries where women have the power to leave, women have the power to say no. If you're in a relationship in the West, in a country where the divorce rate is higher than 50% and people have lots of opportunities and options to get out of unpleasant relationships, then you have no excuse if you feel like you're being continually raped because your husband wants sex from you. And I think that's a really, really odd attitude to have. So, and I also think there should be a difference between this physical rape, physical harm, and counterfactual thinking, which is the idea that after doing something I didn't really enjoy, not having said no, not having asserted myself as not wanting it, didn't really want to hook up with this guy that wasn't so great, I now feel like he violated me, and I want to put the pressure on him to feel as if he's guilty. And then the difference between that and actually being physically assaulted, physically held down, and penetrated, I think there's a massive difference there, and I don't think the law and the definition of rape accounts for that.
I do a lot of work in the field of reproductive health. The phrase that I've heard used is, sex is hot, contraception is cold. That's the difference between it. Now, the reason I'm making this point is because I'm sort of getting a similar kind of sense about this discussion, that seems to me a massive disconnect between the way that people experience and think about sexual relationships. Real life, it's messy. Things are very unclear. It's all a sort of a negotiation, sometimes explicit, sometimes non-explicit. And the discussion that happens in legal and policy circles, which would like to make everything kind of clear and make everything sort of kind of regulated. And I think that is problematic, because I think what you end up with a lot of the time is disorientating people, because when they're told that their instincts are wrong, that their attitudes are wrong, and that they should be looking for example, very formal mechanisms of consent, whether you're looking at the man or the woman, and trying to sort of bring these rules, legal rules, into real life, intimate sexual relationships, I think it does just create a situation where people find it even more difficult to know what they're doing. So I would kind of caution for having a bit less law, really, in the area of intimate life.
Well, I think that social attitudes to women and rape have changed a lot in the last 20 years, and that's really my point of departure with Marguerite Russell, because it seems to me that many of her ideas were formed in the 1970s and they haven't really been updated. Now, let me just look at some of your arguments. You see, I don't think you can infer much from the fact that it used to be a treasonable offence to rape the unmarried daughter of the monarch. That merely represents the dead weight of history. If you want to infer anything from that, it's the fact that that offence is now in any event gone. Furthermore, you cannot infer what you want to infer from conviction rates. It is undoubtedly the case that if weak cases go before the courts, then acquittal rates will be high. And I would rather than say that the low conviction rates for rapes is a problem of attitudes in the courts, it is more likely to indicate that there are many cases that now go before the courts that shouldn't go near the courts. Now, unless you are going to attack the jury system and the basic law of rape, which no one has done, and I'm not going to do that, I'm going to be a passionate defender of the jury system, I'd like to know what other explanation you give. So that is what it seems to me. This shows that there are many cases, because of these changed social attitudes, particularly by the authorities, attitudes towards women and rape, that there are now many cases that go before the courts that shouldn't get anywhere near the court system. And my question really for the panel is, why is that happening? I would like to suggest an answer. Isn't it because if you look at what is essential about a legal system, it is that instead of people resolving problems themselves, they hand the problem over to an independent person, the judge, who's acting on the basis of laws. Now, obviously, with rape, properly understood, it is entirely correct that those matters go before the courts. No woman should have to shoulder the responsibility of taking the offender before the courts to get justice. But why is it that there are these other cases that go before the court system that shouldn't go anywhere near the courts? Isn't that because we now live in a society where we do not respect the autonomy and independence of individuals? And with many of the cases that go before the courts, these cases should be sorted out by the individuals concerned resolving them themselves.
I gave the example, starting with that last one, I gave the example of the treason just to contextualise a long history and a very short history that's come against it. Attitudes have changed. Look at the taxi driver case. Metropolitan London. Women are saying they got in a black cab and were given alcohol to celebrate something and then raped. And the police treated it as if they were nuts. Look at the Reed case, sexual assault in 2004, 71 separate offences subsequently. Why? Because the police didn't take a DNA test. They didn't take it very seriously. I'm sorry, but if you read the Stern report, yes, there have been improvements. But the idea, just as the idea that women's equality has suddenly magically happened, is absolute nonsense. It hasn't. The attitude of judges, police officers, it's not just juries. I think juries are great. I think by and large juries are one part of the system that works quite well. But the kind of attitudes that pervade society about women and myths about women and women's behaviour still exist. I would suggest that that young woman who spoke about, how wonderful things are in the West, goes to a battered women's shelter, goes to a rape crisis centre and speak to some of the women there, listen to their experience, and then just see how wonderful things are in the West for some women. Obviously, things have got better for a lot of women. I'm not for one moment saying that. So far as the law is concerned, I read you the definition. When we talked about the anecdote that I gave, if you leave your house open, it's a question of blame. It's a question of making people feel guilty for something. That's the crucial difference. That the responsibility is laid on the women in a rape situation, that she must behave in a correct way. If you read the Stern report, people make assumptions about the way that people behave after a rape. Both men and women. Rape, by and large, is against women, but there are men that are raped too. It gets lost in this conversation.
Great.
And I'm very sorry, but in Canada, the simple idea that if you're going to have sex with someone and you check that that person consents, hasn't created, it's not Chicken Little, the sky hasn't fallen in. It is working.
A couple of points that Marguerite just made. I mean, there's some really interesting research from Canada that this hasn't solved any number of problems there. And in fact, it's really thrown back onto women to make sure that they haven't expressed their consent verbally. So I think you can't sort of find I agree with the women who spoke. It's not the entire solution. I think, I agree with the woman who spoke a while ago who said that, these things are messy. It's very difficult to, you can't find a sort of legal solution to all of those problems. I mean, I do agree with you that, I am talking about the West. I agree that terrible things happen across the world. And I think the Stern Report gives a very balanced view on that there are times when, of course, the police could be more sympathetic. And, there's no... obviously, I think that the police should be as sympathetic and as supportive to rape complainants as they possibly can be, at the same time as trying to do justice. This is quite an emotive discussion, obviously, so I just want to come back to the question of statistics, which have been mentioned a few times, and try to sort of put something a little bit colder onto the discussion. We've heard a few times that the conviction rate in rape trials is very much comparable, in fact slightly higher, the latest research shows, than for other serious crimes. So the conviction rate is around 57% of, the number of times that juries find the defendant guilty is 57% in rape trials, which is higher than it is for other serious offences like, for example, grievous bodily harm, or attempted murder, which I think is a very interesting finding, considering that we are talking about a very messy crime, which usually occurs in private, where you don't have usually independent witnesses to what's happened. So I think the fact that we have got that sort of comparable conviction rate in rape really suggests that attitudes have moved on a long way. It's the case that in terms of the number of cases that are reported, we have again a comparable proportion being of convictions in rape cases. So it's often said that the the percentage of rape cases that are reported, we only have 6% or 5% which actually end up in conviction. In fact, it's nearer 12% if you include other convictions for sex-related crimes. And this compares very favourably with the attrition rate in other crimes. For example, we have an attrition rate of 4% for violence against the person, 10% for robbery, and only 14% for attempted murder. So I think if we look at what's actually happening with reported rapes and how that converts into jury trials and how it converts into convictions, that the evidence is really that attitudes have moved on.
You lie on the beach naked, you're sunbathing, that is not an invitation to any reasonable person that you're available. As bad as rape is, as horrible as it is, in my survey, I found that only about 6% of my students back home in New York were worried about rape on any regular basis, or even irregular basis, intermittently worried about rape. In my discussions with prosecutors back home, I have learned that prosecutors prefer males on the jury, that they think that women are less likely to convict than men, and I find that interesting. Second, the notion that women can say no. If you say that women cannot say no to men on questions of sex, you undermine all of the progress that women have made in the socioeconomic setting. Women are called in leadership positions to say no on a regular basis. If they can't say no to a man about a raise, about a promotion, about a job, about anything, then women cannot be trusted in leadership positions, and I reject that idea.
I think the ways in which people say yes are blurry, but the ways in which people say no are not. I think that rape is not a blurry matter. It should be absolutely clear to both people there that the woman is being violated, because that's what it is, and that's why we try it as such a serious crime, because it's a violation of somebody's sexual autonomy. So that line has to be crossed. It has to be clear in people's minds. That doesn't mean she has to fight, because he may have a knife. And most women prefer to be raped than to be stabbed and killed. It seems to me that we've gone from a situation where women couldn't say no, or couldn't be accepted to be saying no because they're all of men's property, or they're their husband's property. Or in Pakistan, if you get raped, then it's your fault and you get tried, because essentially you've been sullied as a potential future husband's property. We've gone straight to that situation where there was no liberal moment and no point at which women could be actually defenders of their autonomy, because that is why it's a terrible crime, because autonomy has been violated, and that's why we try it in that way. So I think the question is not whether rape is blurry or not. It's the trouble is in prosecuting and having the evidence, which, as Helen said, there were no witnesses. If violence was not offered, then what exactly is the evidence? But I think that we have to improve the prosecution of it. The police, in terms of collecting samples, in terms of having rape crisis centres, those sort of things, improve prosecution. But let's be under no doubt that rape is not blurry.
The way in which the subject of rape has been discussed today, it almost sees it as a continuation of normal sexual activity taken to an extreme. And I do think that is problematic. I'd go along with what the last speaker said, which is that rape has to be seen as a crime of violence that takes a sexual form. And in that context, it's more that rather than seeing the invitation, or seeing someone lying on a beach as an invitation to engage in sex, that again makes it part of the normal range of activities. Oh, you fancy them, therefore you have a go. That's not really what we're talking about. And in that context, I would extend the idea of Foucault, and instead of saying being punched in the face, is that as bad as being raped, extend it a little further, saying, is being stabbed as bad as being raped? Or my experience is having the shit kicked out of you and being made unconscious as bad as being raped. They're all acts of violence, but because it's a sexual form that it takes and the fetishized nature of sexual relations in society, rape feels worse because of the kind of personal violation of your body. And it's the fetishization of it that makes it kind of strange. But primarily, that fetishization has to be stripped away in order to treat it for what it is, which is an act of violence.
I'd first like to make my massive issue with the point brought up over here is that rape, especially in the circumstance of like the husband and the wife or in the already relationship, yes, it's about sex, but it's also about power. It's about the man taking the power, and in that sense, the woman has no power. She can't leave. You can't bring yourself, because there's the mental as well as the physical, which you're completely forgetting. The second point I'd also like to bring up is what this debate seems to kind of be missing is, yeah, if a woman doesn't want to be raped, she should say no. If a woman doesn't want to have sex, she should be able to say no. If she isn't in the mood, she shouldn't go to bed with the guy. On the other hand, legally, she has the right to say no whenever she wants. They should be taught how to stop it happening, but in the eyes of the law, they should be able to say no whenever they want.
Does the panel believe that on the issue of rape, the burden should be reversed from the prosecution to prove beyond reasonable doubt towards the defence to prove that rape did not occur?
I wanted to kind of talk about the conviction rates that were mentioned, and I think it's important that we take those statistics with a pinch of salt. I myself work in a sexual assault referral centre just up the road in Paddington, and we see a lot of women and occasionally men coming in every week who don't report their rape for various reasons. And I think we need to think about the reasons behind the vast number of rapes that do go unreported, the number of rapes that aren't brought to court because of advice from the CPS, because of failure within the law to support those women, and also the victims that don't want to take things further because of intimidation, because of fear, because of terror. The Western world isn't all rosy. There's intimidation from families, from partners, and we need to think about the rape that doesn't go to court and think about what it is we can do to help these women and support these women.
I'm a law student in the United States, and over the summer I had the opportunity to participate in about 6 felony sexual crime trials. And one of the items that I really noted was, even though, like in the United States, just like in the United Kingdom, we've abolished the 3 requirements of needing cooperation, reporting immediately, and no rape by the husband, it seems like juries still have those 3 notions built in, and they won't convict unless you get some version of those. And I thought that would be interesting in terms of what are the attitudes in the community and how can we move towards changing it. And then in respect to those trials that I have over the summer, I practiced in a jurisdiction that's extremely conservative by the United States standards, which probably would mean that we're slightly to the right of Attila the Hun here. But what if a defendant's convicted, or looking at multiple decades behind bars with minimal parole opportunities? And so the question then becomes, to what weight do we append to the defendant? Are we, by lessening a rape standard, are we basically saying we're lowering the reasonable doubt in rape trials?
I think we should be very careful about assuming we've reached some ultimate endpoint of female empowerment. There are often very invisible social norms that are constraining female behaviour, and we've heard evidence of that today in that women are saying no or saying nothing when they mean yes. They're not doing that to exercise some conscious sexual strategy to tease a man. It's because they're picking up on wider social norms that mean that they feel that if they are seen to actively initiate a sexual encounter, that they will be seen as somehow unchaste or unfeminine. So you've said that we're doing a disservice to women if we assume that they can't say no, but your own research has shown that women have a difficulty even saying yes and in making any active choice. So we need to look at wider social norms here.
A little bit on the subject of attitudes. I think that sometimes we're looking at attitudes to women, but also like in the whole discussion of rape and how women responsibility as well. Sometimes it seems that we sort of assume that any man on a night out who sees a woman wearing revealing clothing is going to want to rape her or want to jump her, anything like that. But I think it's definitely a fact that there are rapists out there and serious serial rapists. And so I just want to ask, is it not better for women to take precautionary measures, like when they go out, for example, going out in groups and making sure they go home together and things like that, just to avoid the possibility of being raped in a situation like that? And also, in the topic of like the jury and who they view as guilty, in a situation if 2 women got raped and the jurors found out that one was a nun and one was a prostitute, wouldn't it be more likely for them just to side with the nun, regardless of the situation in which it happened?
I wasn't ready for that, but because I really wanted to respond to 2 folks who just raised questions. Number one, we're talking about the law here. We're not talking about morality, at least for the moment. So, yes, of course it's true. There are women who are not strong and are not capable of protecting themselves, as well as those who are. But we need a standard for everybody. We cannot have standards for prosecution of rape that depend upon the moral strength of the individual, courage of the individual woman. Secondly, with respect to changing social norms, that has to be done outside of the law also. Either we change the law or we don't, but if we want to change the law in the long term, then we have to change the norms first, and that can't be done through the law first. It's unfair to those who are working within the system.
Anything that takes away from rights of defendants in a criminal trial, there's been such a march in the other way, no. But having said that, that does not mean that everybody has to individually and collectively take responsibility for attitudes which pervade our society, that in some way that, as it were, women are not as valued in either their opinions or their person as men, and that any responsibility for something that goes wrong in sex really lies with the woman, not with the man, because that's really what's underlying some of this.
There's so many things I'd like to come back on, but I'm going to come back on this thing about there being a clear line between rape and sex that a couple of people said. It's actually quite simple. This is the thing that's given me the most anxiety in preparing for this debate in terms of what I think about it. Because on the one hand, I agree with what you're saying in an ideal world, but that isn't the way that the law now is. Now the law has widened its understanding of rape considerably, so that now what consent means legally is agreement by choice with freedom and capacity to make that choice. And it is a very blurry understanding of consent. So while I agree with Marguerite that some of the reforms of the law have been good, getting rid of the corroboration requirement, allowing marital rape are good reforms, I entirely refute the idea that the law is in a good state as it is now. I think the widening of consent in the law is very, very problematic. And I also, to come back to another question, I also think that the focus on the man's reasonable belief is equally problematic and actually very different from the way that belief is treated in other serious crimes. So do I think that the burden of proof should be reversed? Should the man have to prove that he didn't rape? No, I definitely don't think that. But I'm afraid that we've reached a situation where so many rights have been taken away from the defendant that we are nearly there.
Thank you very much indeed.
Something to dance to. Let's do it.